All right, we'll go ahead and get started. So welcome to today's webinar, Data Inventories and Data Maps, the cornerstone of GDPR compliance. All right, first of all, I'd like to point out here at Spirion, we've been getting a lot of customers that have been asking about GDPR. Our customers have been successful in doing data discovery and classification, monitor and protect their sensitive data across their organization. In this presentation, Scott Giordano will be talking about the GDPR requirements around data mapping and how data discovery and classification helps accelerate and replace manual processes related to meeting the GDPR requirements. So at this point, I'd like to introduce you to Scott.
Wonderful, thank you, Doug. And yeah, I do want to reiterate to the audience that if you have questions while I'm doing the presentation, please send them in. We love getting questions. All right, so first up, let's talk about record keeping. Just in general, this whole idea of record keeping for data controllers.
So Scott, what's the current responsibility for data controllers under the Data Protection Directive?
The way it works right now is that every controller has to register, or at least has to be liable to register with every member state. So, for example, the ICO, which is the Information Commissioner's Office in the UK, has registration requirements for data controllers. The CNIL, which is essentially the equivalent of the ICO in France, they have their own registration requirements. The Belgium DPA has their own. Everyone has their own. Some nations don't have them at all. Germany doesn't really have much of a registration requirement at all to speak of. So right now, all of the EU member states either have individual requirements of some form or fashion, or may not have any, but the issue is that data controllers are required to do all these just crazy questions they have to answer with respect to data processing. And this is, I'm talking from my own experience here, that every single DPA that required us, and I'm speaking when I was at a defense contractor, we had to register with all these different DPAs, and everyone had a unique set of questions. And the problem was that it was hugely, hugely tedious and time consuming. I think for one DPA, we spent the better part of a month doing all of our registration filings, because for every third party that you had as part of your information ecosystem, if you will, that was processing data, you had to put a separate annex for them. And then for every subsidiary of your organization, you had to also file a separate document. So you may file several hundred documents in one jurisdiction just for registration. So it was a extraordinarily tedious and time-consuming and expensive endeavor, just not only for internal person time, but for our outside counsel time. We burned up a small fortune on outside counsel expenses, which is great if you're in a outside counsel, but it just didn't really serve us very well, especially since a lot of the questions we were asked were ridiculous questions that were more fit for the 1980s. When data protection was starting to be taken seriously than today. They just were outdated, and you really couldn't answer them very effectively. So just as a practical matter, under the directive, record keeping was just a nightmare, and it really was not something I look forward to. And certainly, I think the DPAs didn't like it as well, because it was a lot of wasted time, and there was really no value in it. If you had something go wrong, for example, if you did have a breach, they aren't going to look at the records. They're just going to call you and ask you what happened anyway. So it's just, I understand why they made this requirement, but the net of it was that it didn't really serve anyone well, and we're well rid of it, as we'll talk about in a minute.
Okay,
so,
Scott, there is a question. So,
yes. Oh yeah.
Where do U.S. controllers that do online business with EU citizens register?
Well, what you have to do, and this is why I'm so glad that we're going to be doing away with this ridiculous requirement, is that you have to go to the site of the respective DPA. So say, for example, that you're doing business in the UK, you have a physical presence there, or you're selling, or you have some kind of equipment connection in there, or what have you. You have to go to the ICO site and then go register, and they'll give you instructions on how to register. And that they don't, I mean, the questions aren't difficult per se, but it's just a lot of work. And if you have, for each individual entity you have there. So say you've got 5 subsidiaries in there, then you've got to do 5 separate filings. And then you may all file them at different dates, and then you have to constantly check and see if you're due for the refiling every year. So every single DPA that requires filing at all will ask you to go to their site. And the problem is a lot of these sites, and forgive me for, I'm not being disrespectful to these folks, but they don't put all these things in English. So unless you have someone local there that can read the local language, or you go to outside counsel locally and have them do it, in many cases, you're kind of questioning what they're asking in the first place. So in many cases, we just had to use local employees to go and read these things. And of course, they're not thrilled with that because they're concerned about their own personal liability that they interpret something wrong. Because a lot of the questions these folks ask, the DPAs ask, just don't make a lot of sense, quite frankly. I was somewhat surprised, and I probably shouldn't be at this point.
Okay, Scott, there's another question. Participants
Sure.
asking if you're talking about the current world or the GDPR world, because they're interested in the
current
GDPR
world. This is okay. Well, we will shift right now to GDPR. That's fine. Current world, yes, you do have to register, but, and here's the happy but, that under GDPR, you don't have to register. So let's go to the next slide here. Okay. So now this is GDPR land we're in right now, folks. So recital 32, it spells it out. It says the controller or the processor, this is new, processors now have to maintain records, which they should have, in my view anyway, but now they're required under GDPR to maintain records of processing activities. So that's great. They've laid down the law. Article 30, they get into the details of it, and they'll say each controller shall do the following. And they give you a laundry list of information that you have to check, that you have to keep track of. So not surprisingly, contact information, why you're processing, description of the categories, the data subject. There's a laundry list. I won't dig into it because we're going to show you in a minute anyway. But this is both for, Article 30-1 is for controllers, -2 is for processors. So again, great news. Processors now have to maintain their own records officially. They, officially did not have to before. So good news there. So let's go to the next slide, Doug, and we'll dig into this a bit more. So what would a data inventory look like? Okay, this is a super bare bones. I'm just drawing from Article 30. So these are just some categories, things. So what are the processing activities? And if you look on the far left, I've made up some names of some applications. You'll probably recognize all of these. The first one I call it Employee Central. It's an HRIS system that you probably are all familiar with, or one of the competitors. Sell Me Stuff, again, that's going to be a CRM system. Reimburse Me, those of you that file expense reports know all about these kind of things. These are just some very typical applications. So what's the processing activity? If you look at Employee Central, it's maintaining employee records. You can be as general as that and still be okay. And then what's the purpose for it? Again, to maintain employee records for the management of employees. A lot of times we use that phrase, employee management, career management for the employees, scheduling, really anything that gives the DPA, or the supervisory authority as they're called now, the idea of what you're actually doing with this information. And then who are the data subjects? In this case, it's going to be your full-time and part-time employees. What specific data fields, and this is critical, folks. This is really where the rubber meets the road, is going and finding the very specific fields. So are you collecting, you're collecting obviously the name and perhaps their home address and their home phone number. Where you get into trouble is national ID numbers. And this is something we had endless discussions about at my former company about were you legally able to even capture national identification numbers. In some cases, the answer is yes, sometimes it's no. So this is something that even with the GDPR, you're going to have to go to local law in many cases and find out if you can even capture. When we take it for granted here in the US that you can just use an SSN for anything, that's not the case in the EU. They're very touchy about that. And so you just have to be very careful about whether you can even do that. But it's important to go and find out what you're capturing. Again, when you talk to the application owners, they can usually give you a list of all the fields that theoretically you can capture versus what you're actually capturing. And then you have to get an idea of what you're actually capturing, because in many cases, no one even realizes it until you start asking questions. Then the next most important one over is recipient list. So who's getting this? Well, when we say recipients, it really means who has eyes on them, who's getting a feed from the database. So obviously it's going to be your headquarters HR staff that are running it. It may be that an employee's manager, potentially. It's definitely going to be the payroll folks will almost certainly have access to this. Either they'll get a feed from it and just get certain fields from it. An LMS, learning management system, just making sure that that employee has completed all their training. You'll usually get a feed of just a couple fields from the larger database into that. One of the real basic questions I always ask in data inventories is, what does this feed into? So HR systems, they may feed anywhere from 5 to 15 different subsystems like travel or LMS or benefits or any myriad of things. And if you don't ask, you won't know. This is, again, one of the just hard lessons is when you do these data inventories, you have to ask a lot of questions to the data steward, the data application owner, whatever you want to call them, the person in charge of the application. And you may have to go back a couple times to get clarification. Next thing up is the data transferred out of the EU? For the US folks that are on the call here, which is probably most of you, answer is almost always going to be yes. So say that you have a third party, even that's hosting your HR system. Typically, the servers are somewhere in the US. They're typically outside of the EU, unless you've built a system that's EU-centric. But typically, everyone here on the call has probably got their systems here in the US, even if working with a third party. So that's transfer outside of the EU. And there has to be a mechanism to get that information out legitimately. So for example, whether it is a privacy shield or there's model contracts involved, whatever it is, there has to be a mechanism above and beyond just a regular contract between you and the third-party provider. So for example, if you look at the data transfer mechanism here, for the first item, which is the HR staff, the headquarters staff, it's an intra-group agreement. So think about a model contract clauses between your European subsidiary and your US subsidiary or your US parent company. That is a intra-group agreement, or IGA. Typically, you'll get all of your EU subsidiaries onto that one agreement. And certainly that's how I've done it in the past. And then we'll sign that with the parent company. That'll be your agreement. It uses model contract clauses. But you could also potentially use privacy shield. There's different ways you can do that. The idea, though, is you want to have a list of all the different mechanisms for each individual application. Each application may be completely different in what mechanism you're using, and so you want to be able to tell the supervisory authority how you did that, because in many cases they're going to want to know. And then also you're going to want an application owner. So who is the person or persons that are responsible for that application? So you may, for example, for the HR system, you may have several people that are responsible for different facets of the HR system. And so you want to put a list of those owners, because those are the people you want to call if something goes wrong. If you wake up one day and you see that you've been breached and some bad guys have gotten into your system, you're going to want to know who to call right away, depending on what information's been breached. And then finally, the last column, organizational and technical security measures. So what I would do here is put a link to the larger policies that you have that govern information security. I mean, you can put a summary if you want to put it there of the actual controls in place, but here, just for illustration purposes, I've just put links to the policies and procedures, and that's fine. The idea behind this, you want a supervisory authority to have an idea of exactly how you've protected individual things, and it may be that you've got a completely different set of controls for each application. That's fine, but you want to let them know that you've thought this through, then you've adequately protected it per Article 32. I'm going to pause there. Doug, I don't know if there's any questions or comments or thoughts thus far.
Is this what it would look like for every organization?
No, I mean, this really is just square one. I mean, when I've done these and doing these now, you've probably got 30 different fields to address all kinds of things. Like, for example, some supervisory authorities want to know not only who has access, but whether they have administrator access or just regular end user access. So, I mean, there's a lot of minutiae here. There's almost no end to it in some cases of just the questions they'll ask you. So what you're seeing here is just the beginning. This is just getting you off the ground. Like I said, this is probably about 8 or 9, 10 fields. You'll probably have triple that when all is said and done.
Great. A question from the audience is application owner from the IT department.
The application owner, typically you'll have two application owners, at least that's been my experience. You'll have one from IT and one from the quote unquote business unit. So you'll have a technical owner and typically you'll have a business owner. So the IT person may be the person that's either the administrator or is responsible for some technical aspect. And then you'll have a business owner from the respective department that's involved in this, and that person will be actually running this thing from day to day. So I know I've simplified the owner, but typically you'll have two owners for every application, if not more. So next up, some challenges in building the data inventory. So we got two challenges in building data inventory. One is just finding what data is in scope. And if you've spent time with us in the past on some of our other webinars, you've probably seen some of the things that we're discussing here, but just for the sake of completeness, one of the issues is just the definition of personal data. Again, I talk to folks here in the US that are very centric about saying, oh, you know, we collect SSNs or we collect, you know, addresses or what have you. That's all the sensitive stuff that we need. You know, if it's a healthcare organization, then they have a very acute sense of what's sensitive. But above and beyond that, people don't realize that the definition of personal data is so much wider, and it's impossible for me to overstate this. In the EU, they have this idea of online identifiers, and an online identifier is just some electronic representation of information that can be ultimately connected back to you. So the idea of IP addresses. And the IT folks on there, you're probably rolling your eyes right now saying, that's crazy. How can an IP address be personal data? Well, the European courts have decided that it is. Even dynamic ones, which is pretty crazy because obviously they're so ephemeral. But the EU, big believer in IP addresses as a identifier. So you've got things like browser cookies, GPS coordinates, MAC addresses, RFID tags, any kind of device identifier or other related identifier is going to wind up as an online identifier. It's just, this is what we're stuck with right now. And this problem is probably going to get bigger, not smaller over time. So just a word to the audience here that when you're searching for all of these things, you're really going to have to take a very fine microscope to everything and getting an idea of what kind of data are you capturing. So you have online identifiers, you have the regular quote unquote personal data like a national identifier number, a phone number, an address, et cetera, et cetera. You're going to have special things. So they have special categories of data like healthcare data and what have you, but they also have, for us, special categories of data are a little bit unusual. So for example, special categories of data include things like religious beliefs, political beliefs, sexual orientation, et cetera, et cetera. So those are things to be on the lookout for as well, and that's tougher to capture, not surprisingly, because it's very very nebulous what qualifies as that. When you're, you know, if you're reading a sentence and someone says they have a appointment with their oncologist, say it's in an email. Well, I mean, is that medical data? Yeah, arguably it is. You know, how do you protect that? And so this is the kind of exercise you have to go through. Whenever you're doing a data inventory is looking at what the email traffic is looking like as well. It's not just interviewing folks. We'll talk more about that in a minute. So I want to pause here. Do we have any questions or comments coming in that you want to address? Otherwise, we'll continue.
Yeah, Scott, how would you address finding online identifiers in the past, or how have you?
Well, how we've done it is, and how we got involved in data discovery way back when, was this issue. For us, we had to find export controlled items. So that's how we got this start in doing data discovery and classification, because you had to be able to find things that were indicative of export control, things that were controlled by the ITAR and what have you. So that technology, that methodology and this is something I got involved with about 3 years ago. And so I just became very enamored of data discovery and classification, because you're having an automated process go through and go look for things that meet certain criteria. And so you can obviously dial it in as loosely or as finely as you want to look for things, but that's how we got to start using data discovery and classification. And now it just happens to be that it works extraordinarily well for finding personal data.
Great. A couple of questions. Is login identifier for applications covered under the GDPR?
Absolutely. Absolutely. Your user ID, login ID, that is an online identifier. So now I'm sure, again, eyes are rolling in the audience here saying, gee, Scott, that could be just about anything. And the answer is yes, it could be just about anything. I wasn't joking when I said I can't overstate this. It's just everything is fair game. Again, I'll give you an example here. I was working with a colleague who had a program that would go and inventory all the software that our company had to make sure that we had all the licensing correct. And so, not surprisingly, it's going and checking UIDs. Well, guess what? Those UIDs, that's now personal data. And so we had to go talk to the vendor and sign a model contract clause agreement with them to address all the legalities of that. So it's amazing how innocuous things can wind up being in scope on this. That's why I'm saying that you really have to take a somewhat jaundiced view whenever you do your data inventory and ask yourself, really, could this be personal data in any context based on this? And I think that's the safest way to go.
Great. A couple more questions. Is there a documented list of identifiers? For example, genetic sequences, brown hair is not, as an example.
Unfortunately, no. At this point, we have not gotten much in the way of guidance by the Article 29 Working Group, which is going to be the European Data Protection Advisor or Supervisor or Board. I think it's EDPS Board. That is the think tank of the article or the current member states. So the short answer is no. There's no definitive list. So for the moment, we're just going to have to ask ourselves, look at a piece of information. Could you combine it with one or two other things and identify someone with it? If you can, it's likely in scope. I wish we had a exhaustive list, but I'm not holding my breath. We'll ever get one.
Okay. Perhaps some guidance. Someone is also looking for a list for guidance on what is considered as PII for GDPR. So same question in a different way.
Yeah, and what's important is, and I know this is frustrating for the American audience here, we have to get out of the mentality of PII. PII is a subset of personal data. Really, we have to, again, go back and ask ourselves, what's the easy stuff? The easy stuff is going to be things that's obvious. Name, address, phone numbers, email addresses, social security numbers, things that we're familiar with. But, and I'll give you an example, is a vehicle identification number personal data? Under the standard we have here, the answer is yes, because in principle, you could plug that into something else and go look up the driver. So a VIN under EU law is personal data. And again, eyes are probably rolling in the audience going, oh no, this is ridiculous. But this is the nature of it. So we have to think very expansively. Just about anything can be personal data, which I know is frustrating, but this is just the world we live in. So there's no way to give you an exhaustive list. It's always going to be that same question. How could someone misuse or abuse this and connect this with other data and then identify someone? That's ultimately the test. And really, I look at it from the bad guy point of view. How could bad people who get access to this use this to combine with other data to identify people and perhaps commit fraud, identity theft, etc.?
Great. Do online identifiers have to be combined with other identifiers like name to be considered in scope?
Ooh, boy, that's a good question. They have to be potentially identifiable or connectable with other things to be in scope. The idea is that personal data is something that can be used directly or indirectly. And directly is easy. Indirectly is the much larger scope. So if an item could not be correlated with something else, so it's an online identifier per se, but it could not for some reason be coordinated with something else, then you can make a great argument it's not personal information or personal data as the standard is under the EU. But I'd be very careful about that because you may not be able to coordinate it with other data and identify someone, but someone else may. I'm always impressed by how creative bad people are at making use of innocuous things.
Great. A couple more questions, and just to validate, are transaction numbers, pointers, information like that entering into the definition of personal data?
Oh, they're skirting up to the edge of personal data because again, if the transaction ID, you're going to have to plug that into another database. If that database then you plug it into is going to reveal personal identification, then you can make a very good argument that a transaction ID is indirectly linkable. Therefore, it should be protectable as personal data. I'll give you an example. Employee IDs. Employee IDs are personal data, no doubt. Okay, and so an employee ID, if I gave my employee ID to you, Doug, you really couldn't do much with it per se. But if you could combine it with anything else, which probably wouldn't be tough, then you could personally identify me. So the net of it is that things, again, that are innocuous, like transaction IDs, if they're not personal data, they are very close to it. And I would just presume that they are and treated as such. Again, I know I'm making a lot of work for the folks in the audience, but I've been seeing too many instances where innocuous data just is being used by bad people. And I would be surprised that they could do it, but they do it.
So a question about RFID tags. Humans do not ingest the RFID tags. So why is it considered that? Why is it considered that a MAC address of the RFID be considered personal data?
Because in theory, a MAC address is connected to a box like my laptop, which then at some point can be connected to me by coordinating it with other data. So the idea is that something like a MAC address is not per se going to identify me just by itself, because it's just alphanumeric characters, but you can combine it with something else to identify me. So that's the nature, and that's the nature of most, if not all, identifiers, is that you're combining it with something else to identify you. That's really where the danger lies. If you couldn't combine that information with anything else, you can make a very good argument that it's not personal data and it's not in scope. But the European think tanks have really said, yep, RFID tags. They actually call out RFID tags in the GDPR, by the way. So I mean, that's pretty much settled. So as a practical matter, all these things that I'm showing up on the screen here, these are all personal data for all intents and purposes.
So you've covered a lot of different things that might fall under personal data. What is not, as a general rule, perhaps what's not personal data?
Oh boy, if it was, oh boy, that's a great question. I mean, really, think about it. If there's any data that is purely machine to machine that is involved in, say, a back end system, like you can make an argument that even something like, we'll also say like PLM information, product lifecycle management information, so information that you're processing about a product, you're likely not going to have, at least I don't think so in my experience, you're not going to have a lot of personal or any personal information in there because it's just about your product. So it's a good example of a back end system that really is likely not going to be in scope. Now, something that's not terribly dissimilar though, ERP. Okay, think about all of the purchasing capability for that. You're going to have names and addresses in there of contact information of the people that you have to bill, because typically in ERP you're going to have pay to or bill to or whatever it is, ship to, and you're going to have personal data in there, people contact information's name. That puts that in scope. Is it a big scope? No, but you still have to account for it. And I think that's where people sometimes get off the road, is they think, oh, there's really nothing special here. It's just contact information. Well, you know what? Unfortunately, under the GDPR, even before that, under the directive, email addresses are personal data if they identify someone, if they have their first and last name or first initial, last name kind of thing. That's it. So that's a long way of saying that just about everything, unfortunately, is going to have some connection to personal data, unless it's purely product related or mechanically related to something on the back end of your organization.
Great. We got a few more questions coming in. Pseudonymization. How much, which is referred, how's it technically achieved? Will you be addressing that later in the presentation, or would you like to address
won't.
it now?
We can address it now because I hadn't planned to talk about it. Unfortunately, we don't have almost any guidance on pseudonymization. I mean, those of you that work either in the payment card industry or are involved in PCI compliance, you're familiar with the concept of tokenization, which is really what pseudonymization is, said another way. That's the only time I've really had any experience with tokenization or pseudonymization. We haven't gotten any guidance on it. And frankly, I just don't know why the European Union is so in love with the idea. but they are. So the short answer is I don't have anything useful to share with you at the moment, but just stay tuned to Spirion's website, and whenever we do get something from the Article 29 working group, we'll put together a webinar and we'll talk about it.
Great. A few more questions. What about collected data,
Sure.
log files, for example, proxy firewall servers? Will this kind of data also be classified as personal data according to GDPR?
Potentially, because it depends on the nature of the log file. So some log files, like server log files, will have the referring header, where it came from, so that potentially, if you collect enough of those from someone, you could identify them potentially. The short answer is it's a maybe. I put log files here on the list because it depends what information you're collecting. I mean, log files often collect IP addresses, and we know that they are per se personal data. So if even one item in a log file is arguably personal data, arguably an online identifier, then the whole thing is, unless you find a way to somehow isolate it. Maybe it's in a different table or something like that. I've seen organizations where they'll throw things in different tables and just combine them all at once to create something. That's a possibility, but generally speaking, you consider your log files personal data at this point. I know a lot of people are probably ready to scream right now that everything seems like it's personal data, but this is the world in which we live right now.
Great. And just to confirm, that would include unstructured data. So the question is, do organizations need to look at unstructured data issues while doing their data flow mapping?
Absolutely they do. And it's funny that you mentioned unstructured data, which we would just call loose files in email back in my e-discovery days. It's much the same exercise that you're going to have to go through these things and do some data discovery and get an idea of just what personal data is embedded in these documents. Because a lot of times, Microsoft Word, they were really well known for embedding all kinds of identifying data in their documents. And I know that since that time that they've had scrubbers come in to be able to scrub out data. You can do it now automatically in Word, but you're going to have to do and just start doing searches, doing data discovery, and looking through your unstructured data, because that's going to be an excellent candidate for personal data that you wouldn't have thought to look for.
Great. Next question. Participant asks for your view on this. So she states, I see you're approaching this on a system-by-system approach. We're looking at it by department. So what data does marketing collect, for example? What data does product management process? And they also would have IT looking at all the systems such as ERP, HR systems, et cetera. Any views on this?
I mean, as far as an approach of going department by department versus application by application, I think that's fine. I don't see any problem going department by department, because different departments are going to have their own separate issues. HR is going to be probably your biggest challenge because of the idea of employee data being especially toxic. And again, I'm presuming you're not in a highly regulated industry. So healthcare, if you are, then you've probably already had to solve this problem already, because that data is so sensitive. But for non-healthcare organizations, then the issue is going to be HR is going to be the first place you go to. Marketing is probably number two, especially if you're a B2C play, because you may have all kinds of data that was collected that you probably can't use. And I know, again, people are going to be ready to choke me right now, but a lot of organizations that have bought lists and way back when, and still have that data in their databases on EU folks, much of that's going to have to be tossed if you can't find a way to validate that you got permission from the data subject to use it. So yeah, go by department is fine. So HR first, marketing is second. And then again, if you're a B2C play, go to your products. If you sell apps, for example, apps are just notorious for leaking data and sharing data and accessing data they shouldn't be. So that's probably a separate project by itself, just going after your apps and seeing what kind of data they're sharing and leaking. You'd probably be shocked at what you'll find. So the answer is yes. If you're a B2B player, you'll have less work, I think, potentially, but still a lot of work, because it's just amazing the data that we share that we didn't realize we were sharing until someone asked.
So when you talked about unstructured data, you also mentioned that healthcare organizations, for example, healthcare organizations may get a lot of faxes. So paper or
Yep.
scanned data as an image is certainly in scope of GDPR.
Absolutely. Paper records, no question about it, they are in scope. So if you're storing those things in one form or fashion, then yes, you've got to go and account for that as well. Account for whoever you're sharing that data with, to make sure that, because if they're processing that, say that you're an insurance company and you're processing payments for medical stuff, then you're a processor and you're connected with that healthcare organization. Yeah, they're going to be asking you a lot of hard questions about your posture on that. Absolutely, and we'll talk a little bit later in the broadcast about third parties, but the net of it is that yes, absolutely. The short answer is yes.
Great. This looks like the last question. Regarding data subjects, do international exchange students qualify?
Oh boy, we've had endless arguments about this. Endless arguments. Here's the problem: is that this law, in theory, is limited to two instances. One, where you're offering a good or service into the EU, or two, you're studying the behavior of EU data subjects. So studying behavior meaning that you're buying data and modeling it, trying to get an idea of what someone's likely to buy, for example. So here's the thing: is that if your educational institution is advertising, and you're advertising to folks in the EU directly, it's not just a website that you can access from the EU, but you're actually actively selling your service, your educational service, then you can make a very good argument that GDPR applies to you. Now, I know some people will say, no way, Scott, but that's my position at this point based upon just little reading of the law. Now, suppose that someone comes over here as an exchange student, you've never advertised to the EU, you're completely siloed and insular and all that stuff. You can make an argument, a very good one, I think, that the answer is no, GDPR doesn't apply to you, that person gets the benefit of FERPA, okay, which is dealing with student records here in the US, but that's it. And again, I know, and please don't send hate mail, this is just my opinion, but that's what I think it ultimately is going to wind up being, so.
Okay, we seem to get this is a very hot topic. So would incidental data be considered in scope? For example, if a customer sends data that may contain personal data elements as a result of technical support within a record or support file?
Yes. And this is something, and this is often what captures organizations. And I'll give you a great example. Say that you're making communication software, unified communication software, and you're selling it to healthcare organization, we'll say, for example, and you need to be able to remote in to troubleshoot, and you're likely going to see healthcare records. Yes, you are in scope for GDPR, no question in my mind. And I've got clients that have retained us just to go address those issues. And this is a common issue. If you are just a regular quote unquote software provider, but you have to remote in to go do troubleshooting, and you're going to see records of the EU folks, then guess what? You're in scope. So it's the nature of the law, unfortunately.
Okay, great. There are a few more questions. What we'll do is we'll address those in the interest of time. We'll address those by email. Sure. And reply to people.
Sure. Yeah. Please, folks, just ask as many questions as you want. If we miss them, we'll just package them up in an email and we'll just send them to everyone when we're done. So the other challenge in building a data inventory is the fact that I think it's important to start with interviewing the owners, both the technical owner and the business owner of an application. And I use the word application very loosely. You may not have an application. It may be a process. You may be a company that just analyzes third-party data that you're given. That process still implicates personal data. So whoever's in charge of that, it could be the product manager, it could be someone else, but you really want to interview the technical owner and the business owner or owners, as the case may be. Problem is that they may be new to the job. They may be new to the organization. The organization may have not kept any records. And so I know, because when I've done interviews, people have said, oh yeah, we really thought about X a long time ago. We never documented it, but we thought about, personal data in this application. Well, that's great. Now we need someone to document it. And so that's why, again, using data discovery and classification to go through the information ecosystem and check and see if they actually, their understanding is correct. I can't tell you how many times we've done searches and found stuff that we didn't realize was there. And so you want to find out now. You don't want to find out when anonymous has broken into your website or to your back-end databases and absconded with everything. So I think that covers challenges in building a data inventory. What do we got next, Doug? Okay, so leveraging data inventories for GDPR compliance. The good news is once you've got your data inventory in hand, there's all kinds of great things that you can do with it, and as a practical matter, things that you need to do with it. So data subject rights, so we'll talk briefly about the DSARs, or data subject access requests, which are these scary letters you get or scary emails you get from data subjects saying, tell me what you got on me. Third-party vendor management, very important on keeping tabs on your vendors, because a lot of times these folks are very good with technology and bad with everything else. Information security, we'll talk about Article 32. Really, data discovery is a great mechanism for InfoSec. Breach notification, if you get hacked or when you get hacked and the DPA or the supervisory authority wants to know what's going on, what's been implicated, you'll have that list ready for them. And then data protection officers, to the degree you need one, and you don't always need one, by the way, but whether you have a data protection officer or someone else in charge, they really have to have access to that data inventory to do their day-to-day job. So let's dive right in.
Scott, just a couple of questions.
Yeah. Sure.
At what point in an organization GDPR project should the DPO be appointed, presuming the decision has been made that one's necessary?
Sooner rather than later. So as soon as you identify that you need a DPO, hire him or her or the organization or whatever it is. And when I say hire him or her, it doesn't necessarily have to be someone who's an employee. It could be a third party that's just a specialty DPO, but get them involved. And here's why. Because they're going to want to know what's going on so they can actually make intelligent discussions with the DPAs, the supervisory authorities. So bring them on board as soon as you can and get them intimately involved in all this. There's some particularities that you have to know about. DPOs can't be officers like the chief marketing officer or something like that, but we can save that for another webcast.
So a participant asks, their organization is an SMB, and do they need a dedicated DPO, or how does an organization know they need a dedicated DPO or not?
Well, I can tell you this much: you're going to need a dedicated person to be able to manage your data privacy program, your global privacy program, if you're a multinational. So it doesn't have to be a DPO, and we might as well just resolve this issue right now. On DPOs, really, there's very limited circumstances in which you have to have a DPO. It's really if you process sensitive data like healthcare data or criminal records. I know, and presumably for voter registration, some companies process criminal records to make sure someone's eligible, etc. So the idea is that for that kind of what's the best way to describe it? Radioactive data, you're going to need a DPO flat out. Also, if you're just processing lots of personal data, a mass scale. So say you're one of those companies that has the freeway cameras that watches all the cars go by and you process data on behalf of the county or whatever. And you can see, all these people going by and their license plates, etc. That's a mass processing of personal data. Or if you're scanning their license plates, for example, that's the kind of thing where you definitely want to have a DPO. However, everyone should have a data privacy manager, even if it's a part-time person or something like that. Everyone's got to have someone who has the knowledge of knowing what's going on. The last thing you want to do is get hacked and then have no one know what's going on. The DPAs will just let you have it. They really will. They get really mad when you have no idea what's going on. So that's the best way I can articulate that in a short time.
So if an organization has users that are US-based systems that are residents in the EU, does that make their personal information in that organization system covered by the GDPR?
Yes. If you're physically in the EU and you're US, or really any person on the planet, you show up in the EU, guess what? You're covered by GDPR. So that you're magically transformed into a EU data subject. And so, yes, absolutely, the law covers that person. Again, I know this is going to drive our viewers or our listeners nuts, but that's the way the law works.
Okay, great. One last question.
Sure.
Criminal data, health information, etc. Aren't these all personal data? Are there personal data sensibility levels that this participant needs to deal with?
Yeah, there's two levels. There's regular personal data, and then there's special personal data. So Article 9 of GDPR talks about special personal data. So that's things like healthcare data, political opinions, et cetera, sexual preferences, things like that, religious, all those things. That's sensitive personal data, or SPI. Sometimes I've run into countries that also say criminal data is per se a SPI. So again, that's because right now it's a country by country notion. But as a practical matter, all of those are sensitive personal data. Everything else is regular personal data. I think as a practical matter, there's not a huge distinction. You're gonna have to all protect it, and you're not gonna, you're not gonna potentially put extra layers of protection on SPI versus regular data. I'm guessing that you're gonna use one system to cover everything, so you don't have to build two separate systems. That's my guess, which will ultimately wind up doing anyway.
So no more questions at this point.
Absolutely. Okay, let's go into data subject rights. So Article 15, I'm not going to read this, I promise. So the idea of this, though, is that this is what's known as a DSAR, so data subject access request. A data subject can send an email or a letter to an organization and say, effectively, what do you got on me? And then you have a certain amount of time to go and get back. I think currently it's 45 days, but I think they're going to shorten it to 30, if not mistaken. In any event, you're going to have to be able to get back to them and give them a description of all the data you have on them. And then they have the right to rectify it, to make changes, as it were, to that, to correct anything. And by the way, this is something that most Americans don't know we have in the US. It's called the Privacy Act of 1974, and you can do that for the federal government. And you have the right to make corrections and so on and so forth. So the difference is, though, that now we have layered on top of this the right to be forgotten. So if we go to the next slide, Doug, you'll see that there's Article 16, which is rectification, making changes. Article 17 is right to erasure. So this is the idea that people want to be able to say, look, if you have data about me that you don't need anymore, then you have to delete it, flat out, full stop. So that's right to be forgotten is a better way, but it's right to erasure. And this is just giving organizations fits, because they keep asking me all these questions about, well, does that mean I have to erase every electron in my organization that mentions someone's personal data, their name or what have you? And the answer is no. It's based on a reasonableness test that's implicated in there. You don't have to erase every single electron in your organization. You have to ask what's reasonable, what is necessary to serve this person. If, for example, again, the example I would use, if it's an employee, they've left the company, but you're giving them benefits, some kind of medical or healthcare benefits, or some other kind of benefits, and you need their contact information, or you need that information you have about them to provide the benefits, or provide a pension, whatever it is, then you wouldn't want to destroy that data, because then you couldn't provide that to them. So there's always a baked-in reasonableness argument, but you still have to have a very good idea of what data you have about them to begin with. The last thing you want to do is look like that you're not telling the truth. You're going to get spanked by the DPAs. They love doing that kind of stuff because they can. So that's data subject rights. That's the short version on data subject rights. So again, another reason why having very meticulous records is such a huge help, because say, for example, you get 100 people that write a DSAR and say, hey, tell me what you have on me. You could have someone just spend all day as a job just answering DSARs. And especially if you get hacked, you can bet everyone's going to be writing and asking for what information you have about them. Or if a competitor gets hacked and they do business with the competitor, but they also do business with you, they're going to want to know, what you got on me? I know what competitor X has got, and it's a disaster. So this is why you have to be prepared now. Don't wait, because it's just going to look like a complete circus if you're not ready to answer a DSAR. Let's go to the next one, Doug. All right, so third-party vendor management. One of the things I'm very happy about for GDPR is now vendors, third parties, processors, we're going to call them, are more or less held to the same standard as data controllers, which it's great. And as a processor, you're going to certainly have to have your own Article 30 records. And in particular, when you finish processing for someone, if you look at Article 28.3 sub G, at the choice of the controller, delete or return all the personal data. And most likely you're going to wind up deleting it. So if you're going to delete it, you're going to certify that you deleted it. And you better, if you're going to certify, better actually have information that is consistent with that you actually did delete it, meaning that you have to have your own meticulous records, getting an idea of what you have to begin with, and so that you can answer the question, yes, I deleted everything, I got rid of it all. Also, for sub H, make available to the controller all information necessary to demonstrate compliance with the obligations. And boy, I'll tell you, I wish processors were more cognizant of this. I'm seeing them start to become better, but so many processors, again, are very good with technology and very bad with everything else. And so this is something that right now can be a real burden for them. That's why it's so important to get your third parties on board for GDPR compliance now and not waiting till next year. I can tell you that it's going to be a lengthy process for some of these folks. InfoSec. So Article 32, there's really two pieces to this. One, Article 32 requires you to provide appropriate technical and organizational measures to the organization to protect personal data. I think you're all probably well versed with that. So what's interesting about this, though, is that, and if you remember from earlier when we had the data inventory, the sample, I have a column there just for citations to your InfoSec policy. And you may have an InfoSec policy that's general, you may have an acceptable use policy, you may have an encryption policy, et cetera, et cetera. Another thing that you have to be able to show, or at least they suggest, they being the EU suggest you show, is here, 32.1d, a process for regularly testing, assessing, and evaluating the effectiveness of these measures. So what do you do with that? Well, you're going to be running all kinds of audits and tests, and a great thing, again, is data discovery and classification. After you've built your entire system, using DDC to come back and say, okay, let's start scanning. Let's have an idea of what information we say we have versus what really is there. So it's a great control to make sure that you're checking things, and you can check this on a differential basis. You can set data discovery up to warn you. If, for example, data classified in a certain way perhaps was loaded onto a USB drive, or it was put in a repository where it shouldn't be, whatever it is, to be able to send a trigger notice and to say, hey guys, hey Mr. or Ms. InfoSec professional, this data of class X was moved on this repository, it shouldn't be, letting you know that. That kind of technology is huge in supporting Article 32D. So you always want to think about all the different kinds of technology you have that can provide an early warning and prevent things from going wrong in the first place. And so data discovery is just one of those things. All right, Doug, we can, oh, good. So breach notification. Breach notification, a big deal for GDPR, not surprisingly. So Article 33 sub 3 asks us for breach notification specifically, and it gives these four things. Now, not surprisingly, if you look at these things, most of them can be pulled directly from the data inventory. So again, not an accident. This is the kind of things you should be carrying on your data inventory. So again, nature of personal data, numbers and approximate types of data subjects, categories of records involved. So essentially, you're baking this all into your data inventory. So if and when there is a breach, you're able to find out very quickly, okay, here's the data most likely to be implicated. And that's crucial because of the 72-hour deadline that you have. Big deal that we did not have before is the 72-hour deadline. And so it's a pretty heavy lift, and I really would take this super seriously because I guarantee they're going to use this, they being the EU data protection authorities, are going to use this as a bludgeon to punish organizations that aren't up to speed on this. All right, and DPOs, and we talked about DPOs earlier, so I won't beat this to death again. We'll just say that you should have, if you don't have a DPO, that's fine. You may not need one, so you'll make an independent determination whether you need one, but you should, emphasize should, have a person that owns your data protection program, that owns the data privacy elements of that. And again, this may be split. You may have someone who's an expert on data privacy and one that's going to be on InfoSec, and they work as a team. That's fine, but you want to have someone you can ask. I know at my former company, I was the guy And so everything hit my desk. I mean, everything. Anything that was remotely personal data questions would hit my desk by people that I didn't even know were in the organization, but they found me and they said, hey, we think that this is a problem. And so I would get contracts and agreements and things all day saying, hey, this website says that we can't do X, or, what can we do? So you need someone who can just answer all those things, or at least push those to the right people. And that's really super critical if you want to have an excellent global privacy program. And that's why that person needs access to the data inventory. I think that's what we have, Doug. I'm going to wrap up here, and I know we're just about out of time, but like I said, keep sending in questions, and we'll review them and turn them around in the next 24, 48 hours. So a couple things. Data inventory, core component of your global privacy program. You don't need to beat that up. I think you guys pretty much are convinced. It is your first line of defense for answering any kind of data protection questions, or if you wind up getting hacked, then it becomes a crisis or a series of crises. It's your first line of defense to be able to find that information. You don't want to try and find it when you've gotten hacked, because by that time, all the people you need to talk to are probably going to be on vacation. That always seems to be the way it works. This is key component for data protection managers or officers. Either way, that person or persons should have access to this. And finally, data protection or data inventory really should be a living document. It's not something that you can just write down once and that's it. You're going to have to periodically update it. And again, working with your application owners is crucial for that. And not surprisingly, using data discovery and classification to make sure that their understanding is correct. So that's what I have for you, Doug. I know we're at the top of the hour, so I'll be respectful of everyone's time, but I'll leave the rest to you.
Again, thank you very much, Scott.
You're welcome.